this meeting. Today is Tuesday, February 10th. I'm sorry, it is Thursday, February 10th at 2 o'clock. And the Tax Review Board is convening with license and inspection cases today. Please be aware that this is a public meeting. It is being recorded. Because the meeting is public, participants and viewers have no reasonable expectation of privacy. By continuing to be in this meeting, you are consenting to being recorded. At this time, I'd like to give the chair the floor to begin the meeting.
Good afternoon, everyone. This is Nancy Cameron. I'm chair of the Tax Review Board. We're going to turn first to a couple of things from the agenda. One is the withdrawal of an item, Sheena Holland, last four digits of the docket 9293. That matter has been withdrawn from our agenda. We also have one thing that's not officially part of today's agenda, but we have a decision only on a matter that had come before the board before. And I don't know if anyone is on this call representing the parties from that item, but it was Deborah and Richard Ball, last four digits of the docket 6989. And in that matter, after reviewing the hearing information, the board has agreed to abate 100% of the interest and 100% of the administrative charge and ask that an installment agreement be entered into within 30 days. If there's anyone who's listening in on that has any questions about that item, this would be the time to raise them.
Nancy, please don't forget the appeal rights and to tally the board.
Thank you for the reminder. As is the usual case with our board decisions, you'll get a letter from us that spells out our decision. Both sides have the right to appeal to the Court of Common Pleas within 30 days of the date of that letter. Assuming that neither side chooses to appeal, then that would be the point in time when the installment agreement that I referenced would be negotiated. We're now going to turn something else.
Just to poll the board members.
Oh, okay. We did vote on this outside the hearing area, but if I could call upon my fellow board members to indicate that they've concurred in this decision.
This is Paula Weiss. I concur.
Dominic Ward concurs.
George Matthews, I concur.
Okay, and as the chair, I also concur in this matter. We now have a series of cases. We've put them basically in the order in which people have shown up for the process. The first of those is for item number 5. I'm not sure if I'm saying that anywhere close to correctly. It's the last four digits of the docket are 9294 and the property address is 2810 West Herald Street. Please identify yourself for the record.
Yes, good afternoon all. My name is Enyi Emesi.
Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, thank you. Who has this matter for the city?
Mikia Clark on behalf of the city of Philadelphia.
And you're the attorney on the case?
Yes.
Okay. Do you have anyone who will be joining you who is not an attorney who needs to be sworn?
Yes, I do. Supervisor Rabakowski is also online.
Okay, please identify yourself for the record.
Thomas Rybakowski, City of Philadelphia, License and Inspections.
Do you swear or affirm to tell the truth with anything that comes before the board?
Yes.
Thank you very much. Do we have anyone who will be giving us the numbers for the record?
Richard Wade, Litigation Court, License and Inspections.
Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, thank you. Does that cover it from the city's end in terms of the people who need to be sworn?
Yes.
Okay, thank you. Do you have any opening comments or should we just go to numbers from the record before we turn to the petitioner?
You can just return to the petitioner.
Okay, well, first we'd like to get any numbers for the record.
This is for the property at 2810 West Harold Street. This is for demolition. Bill date or approximate abatement date 2/19/2019. Labor $11,388.50. Administrative charge $2,391.59. Interest $2,411.50. It's amount to $16,191.59.
Okay, thank you. And if we could turn to the petitioner, please tell us why you're here and what it is you're looking for from this board.
So I'm here today to state my case, and more than state my case, make the appeal as to why I'm unable to make the payments, the numbers as they were just prescribed by Mr. Wade. I did not, so I live in the Massachusetts area, and I was looking to invest in the Philadelphia area. I purchased the property at 2810 West Harold at a tax auction. I had not seen the property prior, and even after I saw the property and I got to the property after the purchase, I did not see a demolition notice anywhere on the property. Now, I also did not receive any demolition notice in the mail, and it's not the first time that I have not received correspondence from the city. I'm not putting anything on anyone. I'm just stating the facts. I did not receive any notice because my actions would have been much different. Even I had overpaid the city for the house, and I didn't even get that refund check until, which they had sent out, but I never got it. So those are two examples of me not receiving correspondence. It was not until I had actually sold the property that I would like literally come to an agreement on selling the property, that the potential buyer or would-be buyer drove by the property and saw that they would that the demolition was going on.
Did you provide your actual address and contact information to the city?
I did. I actually
In what department or where did you provide that information? Do you recall?
I provided it at the time of purchase, and so after purchase and at the auction within 30 days, I have to come into the city to go actually complete my payments.
Did you purchase it from the sheriff sale, or did you purchase it from an individual sheriff sale?
Sheriff sale, yes.
Okay.
And so what I'm trying to say is I am responsible. If I had seen the notice, I would have acted accordingly. I would have made the decision as to whether or not, it was worth me holding on to till I got enough funding to fix the property or to sell it or not even purchase it completely. But I did not have that information.
And I have one question. This is Paula Weiss, a tax review board member. Did you say that you don't own the property anymore?
No. So what I said was I didn't find out about the demolition. So it's funny. I'm literally in the middle of coming to an agreement with a buyer.
Okay, so you still are the owner. That's
Yeah, I'm still the owner.
okay.
Yes.
Thank you.
Any other questions from board members? Hearing none, let's turn to the city for their discussion and input. Excuse me. Go right ahead.
Good morning or good afternoon, members of the board. I'm going to start from the beginning with opening statements. So as previously stated, this case is in reference to a property located at 2810 Harold Street, which was deemed eminently dangerous and subsequently demolished. And the city of Philadelphia is seeking reimbursement for the total cost of the bill in its entirety. So at this time, the city of Philadelphia would like to call its witness Supervisor Rabakowski. And Supervisor Rabakowski, you've already been sworn in. So can you please just state your full name and occupation for members of the board?
Thomas Rabakowski, City of Philadelphia, license and inspections, supervisor of construction compliance assigned to contractual services unit or emergency response. I also serve as the court liaison for the department.
Okay. And how long have you been in this position?
Since 2014.
Okay. And so are you familiar with the property at 2810 West Harold Street?
Yes.
And how are you familiar with that property?
I'm familiar with the case record and also with putting together the packet for the hearing for today.
And have you had an opportunity to review the license and inspections records for this property?
Yes.
Okay. So at this time, I'm going to start sharing my screen with members of the board. Just give me a minute. Supervisor Rabikowski, I'm showing you what has been previously marked as City's Exhibit A. Do you recognize it?
Yes.
Okay, I'm going to scroll to the second page as well. Okay, what is it?
It is a notice of violation indicating the property at 2810 West Harold Street as eminently dangerous. It is made out to the owner of record, and excuse me, I'm going to mispronounce
That's fine.
the name.
Go for
But
it.
as you can see by my name on the screen, they get massacred all the time. But it was made out to the owner of record, who is here today, and the address in violation is 2810 West Harold. The date of the notice is December 3rd, 2018, and it references case number 665720, and it declares the property as eminently dangerous, and it names the locations of the property that are that have been spelled out and declared as eminently dangerous.
Thank you. And is this document kept in the ordinary course of business?
Yes.
And how is this document stored?
It's stored in the database, the old database, which was Hanson, which this document is generated by. And then our new database is Eclipse, and that is also one of our database record keeping software.
And you say that the violation is that the property was imminently dangerous. Can you briefly describe that?
So it was declared as eminently dangerous in that it is a threat to the adjoining properties, threat to the public at large, in that a collapse has occurred or a collapse is possible, and that it is dangerous to the public.
Okay. And can you also briefly describe the conditions at that subject property?
So written on the violation, or the violation reads that it is the interior assemblies that are in question. They are also ordering that the owner obtain the services of a design professional so that they can go through the property and provide the department a report and plans, if necessary, for the repair or the demolition of the property.
Okay. And prior to this notice of violation that was sent to the record address that we have here, were there any other notices sent on behalf of that property?
This property was actually declared as unsafe as far back as July of 2016. So it had been in a state of disrepair, and it had been a source of either unsafe or eminently dangerous status since that time.
And can a person appeal following the issuance of a notice of violation for a property?
Yes, so a owner or a potential buyer of the property can obtain a property cert, which would list the violations on a property.
And to your knowledge, following the issuance of this notice of violation, was an appeal made at that time?
Not that I'm aware of.
Okay. At this time, I am referring members of the board as well as petitioner to what the city has marked as Exhibit B. We'll zoom out of it a little bit. It's going to be 3 photos in this one set. Mr. Rabikowski, I'm showing you what has previously been marked as City's Exhibit B, and we're just focusing on the first photo. So what is it?
So this is the front of the property at 2810 West Harold. It shows the posting that is affixed to the front of the property. There was sheet metal over the entry point, and this posting was affixed to that sheet metal. You can actually see the remnants of an old posting that was weather beaten or peeled off under this. It's the little shadow that goes around it on the right-hand side. This photo was taken December 1st, 2018, following an inspection that occurred by Inspector Carroll.
And just to continue laying the foundation, does this photo fairly and accurately depict the scene on the date and time in question?
Yes.
Okay. And how are you familiar with this exhibit? You can specify.
I'm familiar with the case record in that these photos are kept in the database for L&I.
Okay. And to also walk back, where was this posting posted? Was it the rear of the property, the front of the property?
The front.
Okay. And before we go any further, I'm just going to scroll to the next photos in that same photo set. Which property are we looking at? That is 2810 West Harold Street.
2810 is the property on the right. Not the one that's directly in the center of the photo. It's the property on the right with the posting on the window.
Is this property, right?
Yes,
Okay. So at this time, I'm referring the board and petitioner to what has been previously marked as City's Exhibit C. And I'm just going to briefly scroll through this photo set before asking questions.
I'm going to ask for that you go back to the top photo.
Yeah.
Just scroll back. I'll tell you when to stop. You can stop right there. That's a picture of 2810 of the rear of the property.
Okay. And does this photograph fairly and accurately depict the scene on the date and time in question?
Yes,
Okay. Now, can you more specifically describe what we're looking at in this photograph?
that is the rear bay of the property, the rear side wall in a state of collapse.
Okay. And were these photos taken before or after the notice of violation was sent out?
These were taken before. The notice of violation was generated on December 3rd. These pictures were taken on December 1st.
And from your knowledge and expertise, did the property present any safety hazards or risks to the neighboring adjoining properties or Philadelphians at large?
Yes, this is a common easement. There's an alleyway that goes in the back of this property. So yes, it poses a threat to the public at large.
So at this time, I want to shift your attention to the cost for the abatement. And so I'm just going to scroll past these photos from that photo set. And I'm going to zoom into City's Exhibit E4. So Supervisor Rabakowski, I'm showing you what has been previously marked as City's Exhibit E4. Do you recognize it?
Yes,
I'm zooming a little bit more for you. Okay, what is it?
it is the bid or the printout of the contractors that placed a bid for the demolition of this property along with the neighboring property. We placed out two properties on this block, 2808 and 2010 West Harold Street. The winning contractor was Palmer. There were four bids, Palmer, Manguel, Monticello, and USA. And the winning bid was the lowest bid made by Palmer.
Okay. And is this document kept in the ordinary course of business?
Yes.
Okay. And can you briefly describe that bid process?
So for a demolition or for a bid for a demolition of a property by the city, we have our contractors visit the location. They will survey the location and the condition of the property. They will provide a price. The winning contractor is the lowest bidder.
Gotcha. And that winning contractor, as you stated, is P. Palmer for a total of $22,777 for both properties.
Correct.
Okay. And are there any additional fees that are coupled with the abatement price for a specific property?
In this case, the demolition is one price. Because the city had placed two properties out for bid on the same block, we are required to do an asbestos monitoring and inspection, which means that a asbestos abatement monitoring service is contacted and stays on location in case asbestos is found and remediated the correct manner. And then the plumbing, it's the lateral that is the main sewer that joins to the city sewer system. That also has to be sealed, and there is an invoice that is generated for that as well.
Okay. So at this time, I am referring the board and petitioner to what the city has marked as Exhibit F. There's two photos in this photo set. I'm just going to focus on the first document. Inspector Rabakowski, I'm showing you what has been previously marked as Exhibit F. What is it?
It is the notice of, or it is actually the invoice that is sent to the owner of record for the demolition of the property. This demolition, if you wouldn't mind making the font a little larger so I could read the price.
1 second. Is that good?
A little bit more.
Okay.
Okay, so the font or the price is $13,780 if that's, because the font's still a little too small. But there you go. It's $13,780.09. That also includes a 21% administrative fee.
And this is the bill cost reflected from the date of February 19th, 2019.
Yes, when the invoice is generated and mailed out, that does not have any liens or interest associated with it, as those charges are assessed by revenue.
And is this document kept in the ordinary course of business?
Yes,
And was this bill sent before or after the abatement was completed?
it was sent after the demolition was complete.
Okay. And to your knowledge, was the city of Philadelphia billed for this cost?
Yes,
Okay. And that bill was paid?
correct.
And to your knowledge, was the city of Philadelphia reimbursed for the cost of the abatement for the subject property?
We paid, the taxpayer or the city paid the demolition contractor, yes. I do not have any record whether or not the property owner has paid the invoice.
No further questions at this time.
May I respond? If the board is okay with that?
I just a moment. Were there any other comments to be made by the other parties? You had, in addition to Mr. Revakowski, does Mr. Wade have anything to add, or have you covered everything from the city's perspective?
I believe Supervisor Rabakowski covered everything.
Okay, I just wanted to double check. Okay. Let's then turn to the petitioner for any comments by the petitioner, and then we'll turn to the board for any questions that they might have.
So, and thank you for that. So I have not been to that property or Philadelphia in general since sometime in 2017.
Can you speak up a little bit more or closer to your mic?
Yes, no problem. Can you hear me better?
That's a little bit better. Thank you.
Okay. I have not been to Philadelphia since 2017. I have not seen the property since 2017. What I was doing here in Massachusetts was working and trying to raise money to fix it. As of 2018, or the state that it wasn't in 2018, it was not as severe as it was bad, but fixable by all accounts by the experts, the subject matter experts that I consulted with around whether or not, I could fix the property. And of note, I did not receive those notices. The only time I started receiving notices was after demolition, because I started making calls to the city to say, okay, fine. And that is, for the record, my address that they showed on there. That is completely correct. But the only time that I started getting notices around the demolition was after I started calling after the demolition happened. I spoke to people within the office. I said, I did not get these notices. Go ahead.
I was going to ask if you had anyone in Philadelphia looking in on the property on your behalf during that time.
At one point, but not later in 2017, because when we both went to the property, there was no notice on there. And as you can see, as it was called out, they said there was a previous notice that was where the beating, and I did not see any notice when I went to the property after the purchase, because it would have informed my decision making.
And you said something about the address, but I didn't quite catch it. If you could repeat that, please. Was the address that we saw on the notices that came up your address where you should have received mail?
Absolutely, yes, there is.
So
yes.
the city had the correct address
The city
for
had
you,
the correct
but you were
address.
still not getting the documents.
And I said, like I said before, the city also sent me a check that I didn't receive. And that's on record. I had to call in to get a refund check when I first purchased the property. Because
That's what I put it on the record. I just want to object to that, as it's not relevant to what we're here for today.
What?
Well, it's relevant because I'm trying to prove
regards to the check.
that correspondence from the city, another set of correspondence from the city I did not receive. So it is relevant.
Do any of my fellow board members have questions?
Yes, I do.
So, well, I'll let you go first, George. Go ahead.
Okay. Hello, sir. I saw the address 120 Greenbrook Drive, Massachusetts.
Yes, sir. Stoughton, Massachusetts.
That is the address you live in?
Yes, sir.
Oh, okay. And you are telling us that you didn't get the letter at all?
I did not get the letter. I get my tax letters. I pay my taxes. I pay for water and sewer. And actually with water and sewer, those just started coming after the demolition. And they told me, yes, that I should have been getting them sooner, but I have a payment plan for the water and sewer, and I pay my taxes religiously every year. I get those notices and address them.
So the real estate tax notice also you are getting at this address or somewhere else?
No, I'm getting at this address. I get
This
it, and I paid online. If you would look up, you would see that I'm up to date on my taxes.
Okay, thank you.
Dominique?
Good afternoon. My name is Dominique Ward. I had a few questions. So you purchased this property as an investment property,
Yes, ma'am.
and you said you had a partner you were working with on this
At the time, yeah,
initially.
at the time, yes.
So when you went to inspect the property in 2017 before you purchased it, you noticed there was damage on the property though, correct?
Yes, yes. So at the time of 2018, when they showed you those pictures, the entire back ceiling was collapsed. Before then, there was a significant hole from top to bottom, but the ceiling was not fully collapsed.
So you witnessed firsthand that there was a significant hole from the top to bottom, but there was not a hole in the roof.
No. What I was saying was that when I purchased it, there was still a roof, but the entire back wall was gone. It was not in that exact shape when I purchased the property.
You just testified that you said subject matter experts said it was not as bad. So what did your subject matter experts tell you about the condition of that property?
They told me that it was fixable, it was doable, but this is just me, a naive investor, listening to people telling me that all we need to do is this and all we need to do is that. And then when it comes down to brass knuckles, you find that you're going to pay a lot more than it could ever be worth. And that's why I held on to the property so long, because I was trying to get the money to fix it as I was advised. And then eventually I was like, this is not worth it. I put together a sale, and it so coincidentally happened that was the day it was getting knocked down.
Okay. And your testimony is that you have not been to Philadelphia since 2017. So you have
No.
not seen this property since then.
No, I've not.
Okay, thank you. No further questions.
Paula, did you have any questions?
No, I'm fine, thank you.
Okay. Anything else to be provided, or should we be stepping aside?
I have a few cross-examination questions for the.
Okay, please go ahead.
So you admit that you are the owner of 2810 West Harold Street?
I'm the owner.
Okay. And as the owner, you admit that you are also responsible for the conditions of the property?
Whatever responsibilities an owner has, I own them.
And as such, you understand that you would be responsible for any harm caused by that property?
If that was the case, yes.
Okay. And so you understand that you are also responsible for the full price of abatement to alleviate any potential harm for that property?
If I'm not aware that the city has deemed it destructible, I do not believe so, but I'm appealing that. I'm not forcing it. I'm appealing to the board. I'm not trying to force that, force the board to see it that way, far from. But if I had known that it was deemed for destruction, like I said a few times, it would have informed my decision making greatly.
Okay.
I'm just a young, not young, just an investor trying to, just trying to make it. I'm uninformed. I rely on others, subject matter experts to help make decisions.
Okay, and we're just trying to ensure the safety of all Philadelphians as well. So
And I am too.
I just want to confirm that your record address that was provided to the city of Philadelphia, it's 120 Greenbrook Drive, Stockton, Maryland?
No. It is 120 Greenbrook Drive, Stoughton, Massachusetts.
Massachusetts? I'm sorry. So that's correct, all right?
Yes, it is. I stand by that, yes.
Thank you. I have closing remarks if the board would like to hear that.
Please go ahead.
Pursuant to Property Maintenance 110.6 of the Philadelphia Code, the city is entitled to seek reimbursement of a bill in its entirety from the owners of the subject property as it pertains to the cost of emergency repairs. Here, Supervisor Rabakowski has testified today that the property, which was an adjoining property, was in an imminently dangerous condition and a hazard to both neighbors and Philadelphians as a whole. As such, the proper remedy in this emergency situation was to abate the property, which took place in December 2018. For the reasons stated, the city is entitled and would respectfully request reimbursement of the bill in its entirety.
Okay, thank you.
May I give closing remarks?
If you have any final comments that are different from what we've already heard, please proceed.
I'm just appealing to the board. I have no intent of harming or being a nuisance to the city in any shape or form.
Okay.
Knowing what I know now, I would do things a lot better, and I guess be more present. But I am throwing myself at the mercy of this board to understand the situation from my standpoint, and know that I would never ever want to, bring the city to this point. And so I apologize for, I guess, holding on to the property longer or not taking necessary remedies, but I truly did not know.
Okay, thank you. Is the board ready to step aside?
Yes.
I am.
All right,
Okay.
if everyone, can
We're going to
just-
step aside and we'll come back in a few minutes.
all right, if everyone can just stay where they are, the board is going to be put into a waiting room and then make a decision. Thank you everyone for your patience. I'm just waiting for the chair to return. The chair is back, as is Paula. I don't know where one of our board members went, but we still have quorum. There are 3 board members
We
here.
still have a quorum and yeah, so I guess we can go ahead. After discussion, the board has reached a decision. It's our decision to abate the administrative charge and the interest and ask for payment to be made. See, we didn't set a time period on that. Arrangements for payment in 30 days?
Yes, 30 days.
Okay, we hadn't set a time period on that. You'll get a letter from us that spells out our decision. Both sides will have the right to appeal to the Court of Common Pleas within 30 days of the date of our letter. I'm going to assume for the moment that neither side is going to appeal to court, and in that case, after the 30-day period would elapse, you would be entering into payment arrangements with the city for the balance.
I just want to confirm, what am I being asked to pay? Administrative fees?
I don't have the exact figures, but the bill identified administrative charges and there has been accumulated interest. I think there was, no, I don't have that with the notes that I took.
Sir, I can tell him. We've abated, meaning taken off of the bill, the interest and the administrative charges. You'll get a bill from the Department of L&I with the total.
Okay.
He was asking how much those 2 things were, and I don't have the notes in front of me in terms of the exact amounts on those.
The interest was, I think, 2,411, and the administrative charge was 2,391.
Thank you. I knew they were in that vicinity, but I didn't have them here in front of me. Any other questions before we conclude this part of the hearing?
No, I thank you for your time. I look forward to your correspondence in the mail and going from there.
Okay, fine. Thank you very much.
Thank you.
And your excuse.
George Matthews, I concur.
Oh, thank you, George.
Paula Weiss, I concur.
And
very much.
Nancy Camerodiner. So we have the quorum with the 3. And Dominic Ward participated in the conversation, but we kind of lost her on our in and out there.
Thank you.
Thank you.
She's back. The next case will be number 4, Nancy.
I think we wanted to also, Ms. Clark, we wanted to thank you for your very concise, organized, and orderly presentation. Is this your first time in front of the board?
Yes, in front of this board.
In front of this board? Well, we appreciated how you presented your case. Thank you.
Thank you.
Very good. Thank you.
Thank you. See, our next one is case number 4. Is that right?
Correct.
Okay. The property owner is listed as G501 Realty LLC. Last 4 digits of the docket 9295. The property address is 5105 Brown Street. Who has this matter before us?
Just to clarify, was that GSD?
Yes. Well,
I'm sorry.
I think I gave you the wrong case. I think it's Mr. Slava. I think he's here on 2 matters. I apologize, Nancy. It wasn't number 4. It was numbers 1 and 3.
1 and 3?
Yes. So I don't know who's here for a petitioner for GSD1 Realty.
I can actually resolve that. I think for us, there was a settlement agreement in that case, and that settlement agreement has been satisfied. I suspect that the petitioner is not going to appear because from both parties' perspective, it is resolved.
Please identify yourself for the record.
Yes, excuse me. I'm Michael Rulo on behalf of the city of Philadelphia, spelled RULLO.
Okay, and that is for the case that I identified, GSD, and I apologize for having read it incorrectly, GSD1 Realty LLC?
That's correct. So that matter was settled and that has concluded the matter. So I suspect the petitioner is not going to appear as a
How
result.
recently was that settled? Because I don't think we've received notice of that.
The settlement was only satisfied, I believe, in the past few days.
Okay. If I think we need to have some formal acknowledgement or indication of that from the law department and or from the petitioner.
But
Because
that's the
at
law
this point, we
department.
don't have anything on it.
Nancy, Mr. Rulo represents the
The city, but
department, correct? The city.
the city. And that's why I'm saying we should have something to verify that that's, we have it verbally, but
And
We need
Nancy,
a withdrawal from the petitioner?
I mean, but the city has asserted that there's nothing at issue. So at this point, no action is needed from the board. So
Right.
The board could just simply.
okay.
note
I
that
thought
no
we
action is
should
needed.
have something to verify that it was settled, but if you don't think you need that for the board's records, then,
Not if the city is asserting in this moment that there is nothing due and owing, then no action needed.
okay, we've often asked to have the clarification on it, but I'm okay if my fellow board members are okay in accepting the statement from the city.
Yes, I'll concur with no action needed as our decision.
Okay,
I concur with no action.
okay, and I'm fine to go along with it now that I have the clarification on it.
And Dominic Ward concurs that there's no action.
Oh,
needed.
okay, you're back, Dominic. Thank you. Okay, then, so that takes number 4 out of here, and that leaves us with 1 and 3. Is that correct?
Correct.
And those are Dmitry Arostov, last 4 digits of the docket 9250 for the property at 1950 North Napa Street, and 9251 for the property at 2424 North Stanley Street. Is the petitioner on the call?
This is Dmitry Smirnov, attorney for the petitioner, and we do have the property manager for the petitioner here.
Okay, so you're an attorney, the property manager. If you could identify yourself for the record, please.
You have to take yourself off of mute, Slava.
Slava Stepanov.
Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Thank you very much. Who has this matter for the city?
Michael Rulo, RULLO, on behalf of the city of Philadelphia for both of the Aristov matters today.
Okay, thank you. And do you have anyone who will be testifying for the city who's not an attorney who may need to be sworn?
Supervisor Rybakowski and as usual, Richard Wade will be providing the details. In terms
Okay, and they have already been sworn in, so that stays on the record. Okay, does the city have any opening comments before we turn to the petitioner?
I mean, just briefly, we would be seeking for the total amount identified in the bill along with the administrative and interest fees. So
Are we doing, I'm going to interrupt you a second. Nancy, are we doing one property at a time?
That was part of what I was going to ask, depending on how the city introduced it, because sometimes they do them together and sometimes they ask to have them considered separately.
Since these are 2 separate properties and there's also some different issues, I'd ask for us to divide it up if we wanted to proceed with one.
Okay, thank you for that clarification, and I was going to get to that depending on how you introduced it. Thank you. So which one are you going to take first?
I'd like to start with, I actually think, and I'd welcome Mr. Smirnov's input on this, but I'm wondering if it makes sense to actually proceed with number 3 first, because there are some, I don't know if I would call them jurisdictional issues, but I'm wondering his perspective in terms of whether or not we can proceed on that one today.
Is that the Stanley Street property?
That's correct.
So, right, so the Stanley Street property is up on appeal with the Court of the Commonwealth. We're still in the process of brief and the reply briefs stage of that process. The last time we were here, I believe we moved it out for like maybe 4 months or 6 months. We probably have to continue it again based on the fact that it's with the Court of the Commonwealth Court at the moment.
If I could provide some clarification on that. So Mr. Aristov, after this property was demolished, initiated an action in the Philadelphia Court of Common Pleas. And he alleged a couple of different claims against the city in terms of how that case, the demolition proceeded. The city ultimately obtained summary judgment. The court ruled in favor of the city, and my understanding is that Mr. Aristov has appealed that and that appeal is ongoing.
Well, let me clarify that, Mr. Rulo. So there was 2 decisions that were appealed. One was a summary judgment that the city received that was granted to the city. And then there was a denial of a partial summary judgment for Mr. Aristotle. So those two appeals were consolidated as one, and they're with the Commonwealth Court as we speak.
Either way, I don't believe the board has jurisdiction at this time. This is the Melissa Andre. So at this time, I would suggest that the board perhaps just leaves it open. Because if the court sends it back down, well, I don't know. I don't think that.
If I could, so if I could, from the city's perspective, in reviewing the filings that were made in that case and the issues that were appealed, the legal issues that were appealed in the city's position is that the underlying facts in terms of notice and how this process unfolded is no longer in dispute based on that decision from the Court of Common Pleas. And as such, in our opinion, it is at this time just down to a legal issue of whether or not the city is entitled to collect the relevant monies for the demolition that proceeded here. So like,
But as long as that's with the court, the tax review board, generally speaking, does not have any jurisdiction to take any action whatsoever. I mean, that is normally the situation we face. Is there any change with this particular matter that would still retain some jurisdiction here? Or would we not have
No.
jurisdiction until a court decision is made?
If I could add to that, so Mr. Rule is partially correct. The problem is that the summary judgments that were filed by Mr. Aristov and also by the city pertain to those exact facts, meaning the notice, whether it was received properly, whether it was done properly, entirely the process that would take place. So those are those issues that are specifically up on appeal. So I don't think that there's any jurisdiction on the tax review board's part today, at least, considering there's been no decision by the Commonwealth Court.
So you're counsel for the petitioner, correct?
Correct. I'm also counsel for their appeal.
Okay, so are you submitting to the board today that you feel that we don't have jurisdiction and withdrawing your petition?
Well, the last time we were here, we just continued it because they may bring it back down here. Does that make sense? In other words, it may go back down to the Court of Common Pleas, who may actually also kick it back down to the tax reviewer. And it's quirky because of the scenario that's involved.
So what you're saying is if there's still some possibility in this procedural.
It'll be remanded.
To be remanded.
Yes, that's correct. Maybe not even in whole, but I suspect perhaps in part. Meaning one part of our appeal gets denied, the other one is a little bit stronger in our opinion, and that might get granted, causing the
We
partial.
should just continue this pending resolution.
Of the court case?
Yeah.
if I may, I understand that, the board's position that it's likely going to grant that continuance. The only other thing that I'd like to note is that I don't believe it is in dispute that Mr. Aristov was aware of the demolition that occurred, and I believe he initiated this process after that. And so in the city's view, even notwithstanding the issues in that appeal, this appeal is untimely and nunc-pro-tunc should not be granted here because there was plenty of time for him to file this timely rather than delaying here.
Well, I mean, we're not going to hear the merits of the case right now if we're going to stay it or continue it. So we make note of the city's argument. If it does get remanded back down here, then you can make the argument again. So if we're going to continue it, we'll just continue it.
Understood.
I suggest that we continue this for 180 days and then have either Mr. Rulo or Mr. Smirnoff let us know what the status of it is at that point.
I actually believe it's going to reach resolution by that point, to be honest. We're at that point in the stage of the appeal that I think it'll be resolved by that point, barring any kind
Okay, that's perfect. That means we'll schedule it in approximately 180 days. And by that point, you guys will know what's going on.
Yeah, absolutely. At least one way or the other.
Right, I concur with that.
Dominic Ward concurs with that.
George Matthews concurs.
And Nancy Cameron concurs. So we are continuing this matter for, it was 180 days, if I heard that correctly?
That should be correct, yeah.
Okay, and again, I would just reiterate that if the petitioner or the petitioner's representative identifies any further action from the court and that they advise the board of what happened there so that we know if our jurisdiction is ended or if we have any returning obligations to deal with. That takes us then to item number 1, which has already been identified as read into the record. Does the city have any opening comments on that one before we turn to the petitioner?
Just for this one, we will be seeking the full amount administrative cost and the interest. And I'm not sure if you want me to proceed with the testimony from Mr. Rybakowski first, or if you want to hear from.
Generally, we just get any opening comments from the city, hear from the petitioner, and then return to the city for follow-up on it. Unless there's something else that you want us to know up front, then we would turn to the petitioner to tell us why they're here and what it is they're looking for from this board.
Oh, and please include the dollar amounts in question.
Once again, I've done that. I started out and heading there and then ended up without it. So we need that from the city.
This is for the property at 1950 North Napa Street. This is a demolition. Approximate work completion date, September 25th, 2019. The labor, $13,000. An administrative charge, $2,730. Interest to date, $2,202. The total, and 20 cents. Total amount due, $17,932.20.
Okay, thank you. One of these days I'll get that in there in the right sequence. Now let's turn to the petitioner and anything they have to present.
Sorry, I just started coughing. Give me a second. Mr. Rullo, can you give me that date that you guys have? You said it was something the 25th for 2019. Can you give me that again?
Yes, just one second. Actually, I think that Mr. Wade might have that in front of him. I'm going to need to pull up the exhibit otherwise. Mr. Wade, do you have that date again?
You're muted.
I have it as approximately 9/25/2019, but Tom, the dates on these demolition abatements might be a little fluid. Tom can probably give a better.
I think that's the bill date, right, Mr. Wade? You gave the bill date?
I'll just give me 1 second.
I was able to pull it up. It was September 11th.
Okay, thank you.
So our argument probably isn't like that complex, to be quite frank. We don't deny that notice was received, but we do deny it's not a denial. So what Mr. Slavo testified to, the time period of the actual receipt of the notice and the demolition did not give him enough time to be able to do the repairs required to get the permits that are required by the city in order to get the repairs done. And it just happened with so much speed that he was actually even astonished, and he'll probably testify to that as well. So we're looking for some kind of leniency from the tax review board today. We're not even going to deny the receipt of the notices because the address is correct. It's just the timeliness of the notices between the first one, I guess would say, and then the actual demolition itself. Can I take some testimony from Mr. Stepanov at this point?
Okay, Mr. Slava?
I'm here.
Now, Mr. Stepanov, you know that you've been sworn to, you're under oath with any question that we ask, correct?
Yes.
Okay. You heard my opening testimony, you heard my opening statement, which indicated that we do not deny receiving the notices of the need for repairs, correct?
Yes.
Okay. And you heard my opening statement indicate that the address of 664 Parliament Street, second floor, Philadelphia, PA 19116 is an accurate address for which the city can send notices, correct?
No, the address is PO Box 7122, Elkins Park, PA 19027. That's where it went.
Oh,
All
that's
of
where
those
it went.
notices.
No. Okay. So you also heard in my opening statement that the time between the receipt of the first or second notice from the city and the time of actual demolition was pretty quick. Do you agree with that statement?
Sure, yeah. I even remember that I went to this horrible place in L&I and I've been terrorized by Mr. Thomas, whatever. He was here like previously, I mean, it was absolutely horrible treatment. I mean, they told me that, I mean, it's not enough time. You're not going to do anything. You need to hire the attorney to keep us off this building. Ha ha ha, we'll demolish your building. You know, I mean, not good, you know, not professional, you know, and everything else. So, I mean, the statement I heard at that 11th floor in L&I, that there is nothing you can do. We will demolish that building, whatever you do or you don't, we don't care. You know, we're here to demolish a building, period. That was a thing.
Mr. Stepanov, when the notices were received, did you try to take immediate action to get the property repaired so that it doesn't get demolished?
Yes, you see, what's happened there is that it was a part of a bay, of a back bay of a building, which collapsed. And we were trying to pull the permit, make safe permit, and that's why I went to this torture place in L&I and encounter Mr. Thomas. I'm not really sure his last name. He was just here not that far ago. Yeah, so, and that's when they told me that it's, you know, it's too late, you know, I mean, you need to file in the court to keep us off your building. We will demolish it, whatever you do. That's what's happened there.
Now, Mr. Stepanov, between the time that you had this conversation at L&I and the actual demolition, do you feel you had enough time to get the proper permits for repair, to get the repairs done to prevent the demolition?
Not at all. You need to hire the engineer, you know, I mean, not enough time at all.
Now, Mr. Stepanov, you're in property management, correct?
Yes, I am.
And how long have you been doing property management?
Over 25 years.
Okay, so you do this kind of thing all the time?
Yes.
Okay. In your experience, how much time would you have needed from the first notice to the date of demolition to get this kind of a project repaired? Meaning from the time that how long would it have taken you from the time that you received notice, right? So, okay, so let me go back a second. So you receive notice and then the property gets demolished, right?
Right.
So for a property of this size with the damage that it had, how much time do you think you realistically would have needed to get the proper people hired, the proper permits received from the city in order to get the repairs done?
Judgment by the fact that it took me 3 months to renew my contractor license through L&I, you know, you need at least 6 months because you need to hire an architect or engineer, you need to pull the drawings, you need to come to L&I and be tortured there at least 3 times. Then you need to wait and wait and wait and come back and wait, and then they may be going to issue a permit. At least 6 months, maybe 9.
Okay. But in between that time, in your experience, the city would have demolished a property like this, correct?
Yeah.
Do you have anything further you want to let the board know before we conclude?
Nope.
Okay, nothing further.
I have a couple of questions, if I might, or do you have something else you want to go forward with before we would ask it? When was this property acquired?
Sheriff sale.
When? She said when.
Oh, when? I don't remember.
My question is really, what, if anything, was done with this property to ensure its integrity and to try to develop it for whatever the purpose was of acquiring it between the acquisition and when this notice came?
You see, Miss, we did a lot there. I mean, first of all, we replaced doors, locks, and everything. We cleaned it out, the whole property. It was full of debris. We cleaned it out, and we were actually getting ready to start working on the property. And we brought the new 150 amperes electrical service there. And we were making supports on the back of the property. And
And when in time in what you were doing, did the notice come about the unsafe condition and the potential for demolition?
It's
'Cause
came,
I know you've referenced that this came and there wasn't enough time between that notice and when it was demolished, but I don't have a sense of when that notice came in. I haven't
Not-
seen a date on it.
a
Or if I
notice of
did, I don't remember.
demolition?
I'm sorry. What-
Notice of demolition you're talking? Which
The
notice?
notice that it was imminently dangerous, because the L&I procedure usually calls for a notification of imminent dangerous and calling upon the owner to do something regarding the property before they would actually move to demolition.
I don't remember receiving this note ever. The only note we've got is that, building is going for demolition. That's the only thing we received from City of Philadelphia.
Does the
And when
city
did you get
usually
that?
post them? We can come back to the city for comments on that, but
When did you receive that?
I don't remember the date. It's been 3 years ago.
But you're still testifying that you got it very close to the time when the property was actually demolished?
The notice,
Yes.
yes.
I believe 30 days before or less. And that's why I went to L&I trying to do something. And that's when I've been told that there is nothing you can do.
Okay, thank you.
We will demolish this property. You want it or you don't want it, and we don't care.
Okay.
Just for clarification, you all are not disputing that he received all the notices, correct?
One notice, not all
One,
notices.
I think it's the
Just
one that,
one letter.
yes.
So you're not disputing, though, that he received the notice at the address, the 664 Parlin Street?
No, he said, Mr. Stepan, let's clarify that.
This is
If I
Napa
could just-
Street.
Yeah, if I could just interject, and let me ask him that specific question this morning. So, Mr. Stepanov, you said that the only notice that you received is the one that stated the demolition is going to occur. Is that correct, or is it a different
Yes.
notice?
Certified mail, yes.
Okay. And that one is the notice that said that demolition is going to occur within 30 days or so?
I believe so, yes.
Okay. That's the notice is that the first notice that you got for this?
That's the only notice which I've got.
Okay. So
And
that's
at
the
what
proof of-
address did he receive that notice at?
I believe I signed for that letter at PO Box 7122 in Elkins Park, PA 19027.
Okay. But your mailing address, is listed as 664 Parlin Street, floor 2, Philadelphia, PA, correct?
You see, it's confusing. Both addresses are good, but one
Okay.
address is for tax purposes, another address for L&I purposes, because L&I telling you can't have a PO box, you need city address. It's a mess.
Okay, thank you. No further questions.
Okay, does anyone else from the city have any questions? Does the city, I meant to say, I meant to say from the board, but my apologies. And then now we'll turn back to the city.
Yes, just 1 second.
Did you want to cross the witness?
Yes, please. I'm just gonna need 1 second for the questions. Okay. Mr. Slava, you said that it was approximately 30 days before the demolition that you received the notice, correct?
I believe so.
Okay. And you said that you received the notice right around the time of, it was right, you signed for it around the time that the notice went out. Is that correct?
So again, I received the notice.
Around the time that notice went out, you received it very quickly. Is that correct?
Objection. He's not going to know when it was actually sent out by the city. You'll know when he received it, I guess.
Okay, just give me 1 second. I'm going to put
Sure,
something
sure.
up on the screen.
No problem.
Mr. Slava, can you see what's up on the screen here clearly?
Yeah, it's a final notice of violation in order to imminently dangerous building.
Okay, and is this the notice that you received?
No, I don't think so.
Okay, when did you receive this notice that you're referencing?
I don't remember the exact date. I mean, I received the notice with, which looked like that, but we're saying that, I mean, the building going for demolition.
Okay, can you see what property is identified on this document?
It says 1950 North Napa Street, sir.
Okay, and can you identify what the date of this document is?
April 22nd, 2019.
Okay, and approximately what date was the property demolished?
I think somewhere in September.
Okay, so am I correct that there was approximately 5 months between when this notice went out and when the property was demolished?
Yeah, I guess.
Okay.
I'm not
so-
really sure when this notice was sent, because, L&I sending you a backdated documents, they sending you documents which, laying down there for 3 months, you can't.
Mr. Slava, the editorializing is really not necessary. We just want to know what the facts are of the case.
Earlier, you described that you received a final notice knowing that the violation was going to occur, correct?
I'm not really sure what is that.
Did you not describe that you received a final notice saying that the demolition was going to occur imminently?
Yeah, I received that document, yes.
Okay. And what does this document say at the top in red?
This document, which I'm
Correct.
seeing on the screen, saying this is a final notice of violation.
Okay. 1 second. Okay. You said that you're the property manager for this property, is correct?
More or less.
Okay. Do you know approximately how many properties Mr. Aristov owns?
How it's relevant?
I'm sorry,
I'm
what
not
was that?
sure. I'm not sure how many properties Mr. Aristov have.
Okay, but it's multiple properties, correct?
I'm going to agree with Mr. Stefanov. Objection is to relevance. I don't think it matters how many properties he owns. We have to focus on a specific property. I think that's what it should say.
But I think it's relevant to the inquiry here how Mr. Aristov is taking care of his properties. In the initial testimony, the witness was describing how he does take care of properties. I think
But he
it's
never
relevant
said-
to show how many properties he has, to show that he has knowledge of what he has to do to maintain properties.
Mr. Aristov
Oh, but
pays
hold on,
his
hold on, Slava,
taxes
hold
on
on.
time.
Slava, don't say anything. Mr. Stefanov said that he manages properties. He never mentioned that he manages multiple Aristov properties if there are multiple Aristov properties. Even if that's the case, that there were multiple Aristov properties, the singular focus should be on Napa Street, nothing else. Because there could be, every other property could be correct if there are multiple properties, correct? They could be completely fine. If this one's problematic, then this is the only problem. That isn't relevant in one direction or the other. It's strictly about Napa Street today.
I'm just going to note that I disagree with the objection.
I was gonna say, the objection is noted for the record. Please move on. Thank
Okay.
you.
Can you describe what you do as a property manager?
It depends on the property.
Okay, what was your role for this property?
We was cleaning that property. We was making sure that no one getting into this vacant unit. We was collecting estimates on a job. As I said, we did a huge clean out job there. We put some supports to hold that property. We fixed a roof on that property. We fixed windows on the property. Just keep up.
And that you're saying that was prior to 2019?
Yes.
Okay. And again, when did Mr. Aristov acquire this property?
I don't remember the date. I think 2 years before or year before that.
Okay. So give me 1 second. I'm going to remove this document from the screen and bring up something else. Sorry, I'm having some technology issues here. It does not seem to want to share. Can you see this up on the screen now?
Yes,
Yes,
Is this 1950 Napa Street?
I believe so, yes.
Okay. Mr. Slava, you said that you had done work prior to 2019 at this property.
Correct.
Okay. Do you recognize this photograph?
No,
Okay. Give me 1 second. And Mr. Slava, do you recognize what's displayed in this image?
it's a back bay of a property.
And what's the date of this?
March 22nd, 2019.
1 second, please. I'm going to remove this from the screen. Okay, at this time, I don't have any more questions for the witness.
okay, does that complete the city's discussion? You're muted.
For this witness, I'd like to take testimony from Supervisor Rybakowski next.
Okay,
All
We're
right.
still in the, hold on, excuse me. We're still in the case in chief of the petitioner, or are we now in this, does the petitioner have any other witnesses besides Mr. Salva?
No, we do not.
Okay, so that was across, so now we're on city, okay.
Good afternoon, Supervisor Rybakowski. Can you describe your role, please?
Thomas Rybakowski, City of Philadelphia, License and Inspections. I'm a supervisor at the Contractual Services Unit or Emergency Response. I'm also one of the court liaisons for the department.
Okay. 1 second, I'm going to pull up the document on the screen. Okay. Supervisor Rybakowski, are you familiar with this document?
Yes.
Okay, what is this document?
It's a notice of violation indicating the property at 1950 North Napa Street, declaring it eminently dangerous. It is sent to the owner of record, or the address that we have for the owner of record at 664 Parlin Street, second floor, Philadelphia, PA 19116. It references the case number 680755, and the date on this notice is April 22nd, 2019. Again, it's declaring the property as eminently dangerous, and this notice was issued by Inspector Clark.
Okay, is this a type of document that's prepared in the ordinary courts of business for L&I?
Yes.
Okay, and it's stored by the department after its creation?
Yes, this was stored in our old database, Hanson. We have now progressed to a new database, Eclipse.
Okay, and just for the record, I'm going to offer this into evidence as City Exhibit A. Okay. Supervisor Rybakowski, can you describe the violations that are listed in this property according to this document?
This document describes the property or details that the flooring assemblies are in a state of deterioration or have collapsed and are not properly anchored to and are incapable of supporting nominal loads. And the location for this document or for that are noted in this document are the first and second floor of this property. It also indicates that you need to obtain the services of a Pennsylvania licensed design professional to come up with a engineering report or plans coinciding with the repair or the demolition of this property.
And is this the only notice that the department sends when there's an imminently dangerous building?
Yes, for an eminently dangerous property, the department usually sends out only one notice of violation.
Okay. And approximately how long after we sent this out did we receive the return service?
I don't have that in front of me.
Okay, we'll get to that in a second. Thank you. All right, I'm going to remove this from the screen. Just give me 1 second. pardon the delay, things are not coming up as quickly as I would like when going to do the screen share. Okay, Supervisor Rybakowski, do you recognize what's displayed in this image?
Yes, this is a photograph that was taken of the front of 1950 North Napa Street. It was taken on the day the property was placed out to bid. That day is May 7th, 2019.
Objection, foundation. If
Um,
you want him to testify to the photo, he would have to have the person that took the photo.
Mr. Smirnov, we're not bound by the strict rules of civil procedure, rules of evidence. We can accept it for the probative value.
We could just note that for the record, though.
I'm also going to respond to that objection. It doesn't need to be the person who takes the photo that does it. As long as the witness is testifying that's a fair and accurate depiction of the property, they can testify. It doesn't have to be the person that took the photograph, but we'll just note that for the record.
So for going forward, if either of you want to make objections, please make an objection on the record, state what you're objecting about, but we don't need to do full speaking objections because time is moving along. So if we can make a note for the record, we can move past that. Thank you.
Okay. And Supervisor Rybakowski, what is the notice that is on the door of this property? Excuse me, the window.
So that notice, that bright orange notice, is a notice of eminently dangerous. We post the front of the properties detailing that this property is in fact declared as eminently dangerous by the department, and that that the repairs for either a permit is required for either the repair or the demolition of the property.
Second. Okay, do you recognize this image?
Yes, this is another photograph that was taken on that day of the interior of the property.
Okay, and what does this show in terms of the violations?
It shows the conditions of the interior floor assemblies, that they are in a state of collapse and deterioration. They have lost their nominal loads in that you can see that there are several collapsed sections and missing floor assemblies.
Okay, move on to one more, excuse me. Okay, and what's displayed in this photograph?
This shows another photograph taken from of the property. It is stored in our database records and our photographs under 1950 North Napa. It shows that the flooring assemblies for the second floor are also in a state of collapse.
Thank you. 1 second. And what is displayed in this photograph?
This photograph shows the rear of the property at 1950 North Napa, showing that there is that the property is in a state of collapse.
Second. All right, and can you describe what part of the building this photograph is showing here?
This photograph was taken of the rear of the property. This shows the rear bay in a state of collapse. I know that this was answered by Inspector Madres following a complaint for a collapse that came into our system on March 22nd. It was an emergency call, and Inspector Madres went out to the property on that date.
Okay. 1 second. Okay, and what is this photo displaying here?
This is the final photograph of the grading and the completed demolition. This photograph was taken on September 9th, 2019, depicting the demolition of the property.
And approximately how many days before this photo was taken did the demolition occur?
The demolition was bid out on May 7th of 2019. The final and all the work was processed in our system, and the final payout was done with this photograph by the area inspector on September 9th, 2019.
Okay, thank you. So approximately how many months was it between when the notice was sent out and the demolition occurred?
The notice of violation was sent out in April. It was dated, I don't have that date right in front of me, but it was read into record. But the property was placed to bid for demolition on May 7th, 2019.
Second. All right, I would just note for the record that we are going to offer these photographs into the record as City Exhibit B. Removing this from the screen 1 second, please. Bringing up another document, please bear with me again. This computer is moving very slow today.
While you're doing
Okay.
that, I'll just ask a question and I missed it. I think somebody, what was the date on or about that the actual demolition work occurred?
May 7th, we placed it out to bid. So the bids usually come back. If it's a curbside bid, meaning that the contractors are bidding on it that day, they can start demolition. Whoever the winning contractor is can start demolition within 3 hours of that bid that day. If it is awarded by procurement, they have usually it's the following day, and they can start that again within 3 hours of winning that bid. So in hypothetical, we could have been starting that demolition within 3 hours of them winning the bid on May 7th. But likelihood, they could have started it on May 8th, but the contractor has, once they win it, they can start.
I had some notes that showed demo was completed on 9/11/19 and that the bids were 7/30/19. Did I pick up the wrong information, or are you looking at something different for another property?
I had the same notes, Nancy. I was confused as well.
When I went through some of the documents that were attached
And
to
the-
our information prior to the meeting, I picked up those dates.
Yeah, our
yeah.
exhibits say 9/11/19 is work completed on.
We actually got a date for 9/25.
If it helps, I was about to bring up one of the exhibits that should be able to answer
Okay,
this
maybe you
question.
have what I looked at. I don't know where I saw it earlier today, so I can't go back and find it. But if you have it, that would be great.
Yep, just 1 second. Supervisor Rybakowski, can you see the document I pulled up on the screen?
Yes,
Okay, what is this document?
this is the invoice that's sent to the owner of record for the demolition that occurred in 1950 North Napa Street. It is for the total of 15,700, and I'm sorry, the font's very small, but and whatever the dollar figure is. But that also includes the 21% administrative fee. That's better. It's $15,730.
Okay. And is this type of document that the department prepares in the ordinary course of its business?
Yes,
Okay, and it maintains this document in its custody and control after it creates it?
yes.
Okay. If you look on the left side of this screen, when does it reflect that the work was completed?
The work was completed on 9/11/2019, meaning that the final passing, and you showed a photograph of the final grading, which was from September 9th. So the inspector updated the system and generated the final inspection. All the work was completed, and that's what generated this work completed on September 11th, 2019. This property was placed out to bid on May 7th, 2019. We received multiple bids on this property. In fact, we received 4 bids for this property, and the winning bid went to Monticello. We received four contractors placed bids, and they were awarded the following day on May 8th.
Okay, and now what is the date of this bill?
The date of this bill is September 25th, 2019.
Just 1 second. That does it for my questions for this witness.
Okay. Any questions from members of the board?
Just for clarification, you said that it went out to bid on May 7th, correct?
Yes,
When did the work actually start?
the contractor can start within 3 hours of winning that bid. So typically, when procurement awards the bid, It usually comes in at around 9 a.m. So technically, the contractor can start that demolition at 12 o'clock noon that day. Typically, they don't start that day, but they will ramp up and start fairly quickly. I'd say within the next day or so.
But can you testify to when it actually started?
If you give me a second, I can look at the permit record, and the inspection record would tell me when they had started. Give me 1 second.
Thank you.
So I have the area inspector, Inspector Madres, who was the inspector that responded to the emergency call and posted the property in March, has a notation May 22nd of 2019 as work is in progress. So prior to May 22nd, they were in the middle of doing the demolition. So somewhere in the middle, somewhere between May 8th and May 22nd, they had started the demolition of the property.
Okay, so basically your testimony is today that you cannot tell us the exact date that the work started, but it did happen between May 8th and May 22nd.
Correct.
Thank you.
Am I remembering it incorrectly? But I thought that the notice that went to the petitioner was dated 4/22.
Correct.
So that would mean that it was only a week or two after the notice went to the petitioner that the bids were taken, and sometime shortly thereafter, the demolition actually began. So that seems like an awfully short period of time. And maybe you can explain why it would be so short, but it seems like an awfully short period of time if you are expecting the owner of the property to take action to correct the problem.
As you can see from the photographs from March, that the property had already started and had already suffered a collapse. And our fear is that the collapse would have endangered the neighboring properties. So yes, we did put the notice out, and yes, we did move to demolish the property, but it was not before the appeal period of the notice of violation, nor was it before the date on the notice of violation.
Okay, thank you. Anything else from the city? Any other questions from board members?
I do. Could you confirm for me how many violation notices were sent on this?
For a notice of violation on an eminently dangerous property, we typically, and for this property, we send one.
Okay, I'm looking at the exhibit packet that we received earlier, and it looks to me as though there was a March 22nd notation, 2019. Can you explain what that would be?
March 20, is there a documentation on March 22nd, or is it a notice of violation?
It says notice of violation.
And it's dated March
3/22, 2019. It's page 17 of 24.
If I could, board members, there was an error in the that portion of the exhibit. I believe that notice of violation is for a different property.
Okay, thank you.
And I will resubmit that exhibit so that we have that for the record correctly.
Okay. Thanks.
If I could just, in response to the board's questions, follow up with the witness to clarify something.
Please.
Okay. Supervisor Rybakowski, for these types of imminently dangerous projects, how long does the city give the owner to begin work and comply the violations to make it safe?
A notice of violation for an eminently dangerous property instructs the owner of record to obtain a permit immediately. It gives them the notice of that they can appeal the violation to the appeals board within 5 days, but it doesn't give a specific date on getting the permit.
Okay, and I would just like to clarify, in this situation, the property was unoccupied, but could you describe the risk to the neighboring property specifically?
Being that there was a collapse at the property and the possibility of further collapse, the property was declared as eminently dangerous and that it is a danger to the public, the adjoining properties, and the public at large.
Okay, and then finally, Mr. Slava had testified that there was work done at the property, including the replacement of windows and the removal of debris in the property. Based on the photographs, is that consistent?
I'm going to direct your attention to one of the photographs, the one that is marked or around May 7th. In fact, if you looked at the photograph, there is a gentleman standing in the photograph to the left. I'll tell you when to stop. Keep going. That photograph there, that's from May 7th. That's the letter that is generated that we distribute to the adjoining properties that a demolition will occur. The gentleman to the left in the black hoodie, that is Inspector Brooks. He is, at that time, he was one of our demolition coordinators. As you can see, there is plywood over what would have been the first floor story windows, and the second story window is broken of that property.
Okay, so does it appear that there was maintenance done at this property in a recent time before this photo was taken?
In the way of repair, no.
Okay, and is that consistent with the inside of the property as well?
Yes.
Okay. If there's nothing further, that's my questions for the witness.
Okay. Anything else we need to handle before the board steps aside?
Yes, can I do cross-examinations?
I'm sorry.
Can I just have a few questions for Mr. Rybowski.
Okay. And keep your voice up. I was
Sure,
losing you
sure.
partway through your comments.
Sure. Mr. Rybowski, did you actually physically go to the property yourself?
I did not, no.
There was a photograph taken of the interior. There were two of the photographs that we saw. One, it looked like a ceiling was collapsing, correct?
Yes,
And then there was another one, I guess, of the floor, maybe it was on a different floor, right? You recall those two
Yes.
photographs?
yes,
Did you take those photographs?
I did not.
Is there anybody here from L&I to testify as to the accuracy of those photographs?
No,
So you don't actually have a way of knowing of whether that's the interior of 1950 Napa Street or any other property, correct?
being that they are in the case log for 1950, it would
But
be,
you personally, you're testifying here today, you don't know whether that's accurately depicting the appearance of 1950 Napa Street, correct?
do I know that that's the interior of the property that I took the photo? No. Can I look at
Correct.
the case record? Yes.
Okay, but other than that, you don't know.
Correct.
Correct.
To answer your question.
And the photo that showed the rear of a building, do you recall that photo?
Yes.
Okay, did you take that photo?
No.
So you've never been at the property, you didn't take any of the photographs, and so your testimony is that the only way that you know that that's the interior of the property or the exterior of the property is because of somebody else's photographs, correct?
Objection. The witness has testified that these documents came out of the records of the department and that they were maintained by the department in that records database for this property. So I'm just going to object as that mischaracterization of testimony.
Thank you.
Who did that?
Noted for the
Okay.
record.
Okay. Now, you had also testified, I think it was towards the second part when Attorney Rulo was questioning you, that on 5/7, you had given notice to the adjacent properties that a demolition was going to occur, correct?
Correct.
But the only notice that you sent to the owners was from April 22nd, is that correct?
Correct.
Okay, so you notify the neighbors next door, but you don't notify the owner, correct?
No, we notified the owner by the notice of violation that they have to repair the property either by obtaining a permit for the repair or the demolition of the property. But those notices are to the, they're a notice that goes to the neighboring properties that a demolition will be occurring on their block.
On their block, okay.
Yes, sir.
And again, I just want to clarify that the demolition took place less than a month following the issuance of that April 22nd letter to the owner, correct?
Correct.
Okay. In your experience, in the span of 30 days, is it possible to get a permit from the city, do the repairs, and make sure that this is not a collapsing property or imminently dangerous?
It is possible that they get a permit, depending upon the required repairs for the property. That would be up to the design professional, the permit, and the contractor, and the required inspections that are associated with that permit. But it is possible to get a permit from the department and start work with the required inspections to take place.
But we agree that that process often takes, if not most of the time, longer than 30 days.
No, I'm not going to agree to that.
Okay. Longer than 3 weeks?
No, I'm not going to agree to that.
Longer than 2 weeks?
Longer than 2 weeks? No.
So you think somebody going to the L&I, in your experience, can get a permit, hire contractors, hire architects, get what they need to get done, resolve a problem like this size that you guys claim exists within 2 weeks?
Are you telling me that they complete the repairs, or are you telling me that they obtain the permit?
All of the above. The completion of the entire project.
No.
Okay.
But that's not what we're asking them to do. We're asking them to obtain the permit for the repair of the property or the demolition of the property.
Does L&I provide notice to the owner of a property in this scenario that bids are going out for demolition?
Yes, by the notice of violation, says by the notice of violation and posting the property, those documents state that if you do not obtain the permit for the repair of that property immediately, the city can demolish the property and send the recorded owner the bill of the property along with any associated fees.
It was close, but that wasn't exactly my question. So my question is, when the city provides notice to other third parties that they're looking for bids for demolition, right? Does the city provide that notice to the owner at the same time?
No.
Okay.
I'm
So
going
the owner
to note
wouldn't
an
actually
objection that's
know.
just going to note an objection that question was asked and answered.
Okay.
Good.
So we can agree that the owner would actually never know when the request for bids of demolition are going out, correct?
Correct.
Okay. I think that that's it. I have nothing further.
Okay. Are the board members ready to step aside?
Yes.
Yes.
If I could just do a brief closing statement.
Oh, I thought you had. Oh, my apologies.
So there's just a couple of items that I just want to note. First, the witness, so I believe that counsel for the petitioner, along with the witness, acknowledged that they received the notice and that they signed for the notice here. Despite that, the appeal was not filed until March of, I believe 2020 was the date of the appeal. So it was very untimely, despite them having substantial notice of the deadline. So I think that on its face, there's not an excuse for that delay that would confer jurisdiction to merit even hearing this appeal. But the second item here is that the argument of the petitioner is I believe he had said that they wanted 6 to 9 months to correct the violations here. As Supervisor Rybakowski described, this property was imminently dangerous, and that is clearly supported by the photographs, which also demonstrate that there are buildings attached to this one. I also think that the photos demonstrate that the notion that there was regular maintenance being done on this property, it should be given very little credibility given what the status of this property was when it was declared imminently dangerous. And in this context, what Supervisor Rybakowski testified to is the fact that when there is this type of imminently dangerous situation, the work needs to be, the process for complying it needs to be done quickly. And he did testify to the fact that in these emergency situations, the department does work with property owners to issue permits at a quicker pace than would be done for a typical project. So the final thing that I'll just note is that while this was definitely a condensed time frame, this is something that has to be done to protect the citizens of Philadelphia, and there was no dispute that there was notice here.
Okay.
If I could just add like a minor closing, if I could, just to respond. The city produced multiple photographs, only one of which showed the actual address of 1950 and what we believe, I guess, is North Napa Street. The interior photos that were produced, the exterior photos, we have no way to know whether or not those photos are actually of 1950 North Napa, because as Inspector Rabakowski stated, he didn't take those photographs. Somebody else did. That person was not here for us to be able to cross-examine as to whether the accuracy of those photos are what the city is saying they are, which is North Napa Street. Now, when you look at the 1950 North Napa Street photo where you can see the actual digits 1950, that does not look like a building that's in imminent danger of collapse to the extent that the city would go ahead and demolish it within this fast of a window. So as far as we're concerned, we do not believe the city has proven their burden to show that, yeah, this was an imminently dangerous building and it had to be demolished within 3 weeks of the initial notice. In fact, the only notice that they provide to the owner.
Thank you.
Thank you.
Board ready to step aside?
Yes.
Okay, if everyone
Thank
could
you.
put, the board should be
Thank
back very shortly with the determination.
Hello, Bob. Bob, I'm so happy to hear you. Bob, I'm in a court hearing right now. Can I call you back like in 15 minutes? Thank you.
Nancy, you're on mute, but everyone is back and ready to go. Nancy's still on mute. I know, we're almost at the end.
My apologies. I thought I'd unmuted myself. The board has reviewed everything that we've heard, and it's our decision to abate 100% of the interest and ask for payment arrangements to be entered into after the waiting period. Basically, what happens is you'll get a letter from us that spells out our decision. Both sides do have the right to appeal to the Court of Common Pleas within 30 days of the date of that letter. Going to assume for the moment that neither side's going to choose to appeal. And if that proves to be the case, then at the end of that 30-day period, the record would be updated to show the abatement of the interest, and arrangements should be made between the parties, between the city and the representatives of the property owner to make payments on what remains.
Can we get the number of that interest? I'm sorry, do we have that?
It was $2,202.20.
Okay.
Board, pulling the board, please.
Yes. Do the board members concur?
Dominic
Josh
Ford
Matthews, I
concurs.
concur.
And Nancy Kammerdiner. So we have 4 board members, and we've concurred in the decision.
Okay.
We thank you all for coming and for participating today. And unless there's something else that's come up on the agenda that I'm unaware of, this is the end of our sessions for today, and this hearing is adjourned.
Mr.
Thank
Smirnov,
you.
Mr. Smirnov, Mr.
Yes.
Smirnov, you asked about the docket ending in 8777.
Oh,
I mean,
yes.
we're done. I'm just talking, he asked about something else. Everybody can go if they want.
Everybody
Thank you,
have-
board members.
It looks like this case was actually listed on 125 on a master level. So it was not a board level case. It was a master level case. And there was a failure to appear. And you're still within your appeal period. Did you receive a decision letter?
No.
No? Okay, I'll send that over to you. Can I have your email address?
Sure. So it's my first name as you see it on the thing, on the screen. DIMITRI,
Mhm.
the @sign, and then it's my last name, LAW.com.
Hold on. No, LAW.com.
Yeah, so it's Dimitri at SmirnovLaw.com.
Perfect. I will email you this probably by the end of the day,
Okay.
the decision letter for this matter.
Perfect. Thank you, Melissa. Appreciate it. Have
Not
good
a
day.
problem. Have a really good day. Bye-bye.
You too. Thank you.